Guys, good afternoon. Welcome back to another session brought to you by Accent Nominees. Hope you had a wonderful weekend. I had a wonderful weekend. Before I go into the topic, I will introduce myself. My name is Tomi Oguleye, and the topic for today is legal protection of trade secrets and confidential information. In simple terms, a trade secret is any information that allows you to make money because it is generally not known. A trade secret is any information, including a formula, pattern, compilation, technique, device, method, process that derives independent economic value. In other words, trade secret is valuable because it is kept secret. From the phrase, it implies trade secret. Of course, it has to be kept secret and not being in the open. So for generations, corporations and businesses have continued to protect their trade secrets in order to enhance prospects of long-term sustainability, profitability, and market relevance. So imagine if a manufacturing companies disclose their recipe, how would they be in business? How would they continue to make money? They can't make money. So trade secrets have become a major part of intellectual property, especially with several revolutions in trade and commercial competitions, where companies want to know the recipe of the rival company or the recipe for their product. So entities have strived hard towards the protection of details of products in terms of process of production and ingredients used. So like I said earlier, how do a manufacturer stay in business when they disclose important trade secrets? So let's think back to Coca-Cola recipe. So the recipe for their signature drink. At the time in 19th century, the Coca-Cola was faced with a tough decision, or less an interesting decision or choice, where they were either to patent the recipe for the popular soft drink, or if they patent it, it means they have to disclose the ingredients used, or they brand the trade secret and keep things under wraps. Of course, let's guess the one they picked. They picked the second option, which was brand it and keep things under wraps. So the formula used for Coca-Cola recipe is referred to as the merchandise 7X, which is only known by a few people, and it is also said that it is kept in a vault in Georgia, in Atlanta, Georgia. So individuals who know about this trade secret formula have signed a non-disclosure agreement, and it is rumored that they are not allowed to travel together or be in the same plane. So they have to travel separately just because of this trade secret they all know. So the question that comes to mind, or that you need to ask, is why should trade secret be protected? Or in other words, why protect trade secrets? If you say it's a trade secret, so why should the secret be in the open? So why protect trade secrets where it is in fact a secret? That is, if we claim it is a secret, why is it out? So the World Intellectual Property Organization posited 3 rationales for the protection of trade secrets, which include that protection of trade secrets is to maintain and protect standards of commercial ethics and fair dealings. And the second one they also stated was that it is to prevent competitors from using these innovations without having to shoulder the burden of cost or risk faced in developing innovations. Imagine if anybody can just come out and use your trade secret without being sued. I'm sure everybody will be doing that, but that is not how it works. That is why the legal framework comes in. So one of the major ways of protecting trade secrets in Nigeria is by way of confidential non-disclosure agreement or non-compete agreement, which is popularly known as the NDA. The employer, licensor, or licensor of the trade secret may execute a confidential or non-disclosure agreement with every employee and contractor of the business, most especially those who are exposed or have knowledge of the trade secret. So today I'll be discussing and focusing on protection of trade secrets and confidential information in Nigeria, which is a subset of intellectual property rights in Nigeria. So how are trade secrets protected? Trade secrets, which is another name for confidential information in some jurisdiction, and once it is lost, once it is known by the public, then the value is lost. In Nigeria, like other common law countries, trade secrets are recognized and used, but legislation regulating them are scrappy in nature. Basically, it means, what I'm trying to say is that there is no particular law that regulates trade secrets. Though there are laws that these laws are actually limited to patents, to designs, to corporate and trademarks. So imagine if there are no particular laws that regulate this. How do you protect yourself from going through problems you might be facing? Imagine if your trade secret was known and there was nothing you could do about it. Then basically you are losing money, and then most of your clients people giving service you are rendering for a cheaper price, even if it was more than that, you'll be losing because another person is already offering what you are offering. No more uniqueness. So the trade secret protection in Nigeria is mostly derived from common law. Therefore, persons and entrepreneurs have relied on contract law, tort, and other basic legal principles to prove a claim for misappropriation of trade secrets. So one way to protect trade secrets, I already said earlier, is by signing an NDA or a non-compete agreement. So the NDA could be included in the employment, service, or contract to protect the interest of the originator of the trade secrets in the event of dismissal or resignation. So imagine if it was not in the agreement, and then one of the employee working for you resigns, or you dismiss the person, and then you go works for another rival company, and then start divulging those informations and trade secrets you already learned from you, or you came in contact with in the process of working for you. It wouldn't be nice. In fact, it would be disadvantageous to you. So in the case of Kumolis versus Leventis Motors, this happened whereby the appellant was in employment with the respondent, and he came in contact. He already knows the trade secret of the respondent, and the appellant already signed a NDA, which was non-disclosure agreement, where it was stated that he would not work for a rival company 1 year after his resignation or dismissal from the company, which was what he did. And then the respondent sued the appellant, and then damages was awarded against the appellant. So NDA is actually important. So if you are thinking of employing somebody, and you know he's going to be coming in contact with a lot of secrets that it has to do with a lot of secrets, and then things that if it becomes known to the public, you won't be making money, it won't be valuable anymore. So you have to add your NDA to the business agreement, to the contract, to the employment agreement. So he signs in order to protect yourself from any unseen circumstances or any problem you might be going to, and protect yourself from any future litigation. So obtaining secret information, which is a subject matter of a trade secret, without proper authorization, or when you obtain an information through unlawful means, it can constitute thought of misappropriation. So generally, misappropriation of trade secrets occurs where there is breach of duty or obligation to maintain secrecy. It can also happen where there is theft, bribery, electronic and corporate espionage. So one of the legislation that actually borders on trade secrets is the FOIA. I already spoke about the FOIA in some of our previous sessions, so I'll be explaining some of the things. So FOIA is the Freedom of Information Act 2011. It is one of the Nigerian legislation that borders on trade secrets. Section 15 sub 1 paragraph A. It mandates that public institutions should deny any application for information that contains trade secrets and commercial or financial information that could harm the third party. So if you are initially, you could actually seek for information and they will give it to you, but once it already involves trade secret that could harm the other party, they are to deny the application. So if you are thinking of writing to them just to how will I put it, you are trying to apply for trade secret or commercial or financial information, it would not be accepted, it will be denied. That is basically supporting trade secret. It means they cannot divulge trade secret to you unless authorized, but through unlawful means they cannot. So there is need to contour trade secrets to be delineated. In essence, there is dire need for clear legislation. As there is legislation, we need clear legislation in order to support our business, corporations or startups. And it will allow, if there is legislation, if there is clear legislation, it would allow producers to leverage their business secret for commercial value. Two, it could also protect consumers from undue concealment of information. So the need to protect trade secrets in Nigeria cannot be overemphasized as other countries. So with the increase in technology-driven startups, coupled with adoption of remote working and entrepreneur underpinnings of business impacting technological innovations and other non-technical ideas, there must be comprehensive legal framework to protect trade secrets. So in this instance, as we know that there are not much laws that are backing trade secrets, what do you do? Which I already stated earlier, add your NDA clause to your employment agreement, to the contract, in order to protect you from unforeseen circumstances or anything might go through later in the future. I hope you're able to understand what I said. And then, in case you've not joined us in case you didn't watch a previous session, please kindly do that. You can also drop a question in the comment section and we would reply you. Thank you for joining, and I hope